Okay, this is People of the State of Michigan versus Charles Waits, docket number 20-124FH. This is the time set for sentencing. Mr. Waits, can you just confirm that you're in agreement with doing this sentencing remotely rather than having everybody come into the courtroom?
I do agree.
Thank you. And you were convicted of carrying a pistol in an auto. That is a felony punishable by up to 5 years in prison. You have the right to be represented by an attorney. You are represented by Mr. Marks. And Mr. Marks, have you had a chance to go through the pre-sentence report with your client?
Afternoon, may it please the court. I have had the opportunity to review the pre-sentence report. I emailed the pre-sentence report over to my client, Mr. Waits. He went through it, and there's no need for any corrections, deletions, or additions,
Okay.
Your Honor.
And any objection to the scoring of the guidelines?
None, Your Honor. Thank you.
Did the people have any corrections to the report or objections to scoring?
No, Your Honor, thank you.
Okay. And did the people wish to be heard?
No, Your Honor, thank you.
Okay, Mr. Marks.
Thank you, Your Honor. Just briefly, I would ask the court to adopt the recommendation by the probation agent that seems to be in line with the plea agreement. Also, just to inform the court, I guess this would be an addition. I did have the opportunity to speak with my client about 2 months ago, and he informed me that he did eventually end up taking a firearm safety program. So he understands as far as the mistake he made, and that will never happen again, Your Honor.
That's good news. Mr. Waits, is there anything you would like to say?
No, Your Honor. Thank you.
Okay, so you seem like a great guy in a lot of ways. It says here you're employed, you have a year of college, you have no record, lots of good things to say about you, except driving around with a firearm on your lap is not only a bad habit, it is totally against the law, it's completely unsafe, and it could end up getting you killed. You realize that, correct?
Yes, Your Honor.
So you're never going to do that again, please promise me.
I promise you, Your Honor. It was definitely my mistake, and I've definitely learned from it. And it's definitely a learning experience.
Good, because you have too many good things going for you to waste them by engaging in that kind of behavior and ending up either dead or, with a serious offense that's not YTA eligible and heading off to prison or something like that. You don't want that. I don't want that for you. Nobody wants that for you. So don't ever do that again. You are completely appropriate for YTA status, and I'll grant your petition for treatment under the Homes Youthful Training Act and place you on probation for a period of 12 months, 1 day in jail with credit for 1 day served. You have to pay $130 to the Crime Victims Fund, $68 in state costs, oversight fees in the amount of $120 payable at the rate of $10 a month, costs in the amount of $500 based on the State Court Administrative Office calculated average cost of a criminal case in Ingham County. And now I'm going to go through the conditions of probation. They're really standard ones for you, Mr. Waits, and ones that I expect you won't have any trouble with. You can't use or possess alcoholic beverages on probation or controlled substances or medical marijuana. You must comply with both drug and alcohol testing as your agent directs. You must complete an MRT program. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. No contact with anyone you know to have a felony record. You must contact your probation agent no later than the first business day following your sentencing and placement on probation. You must comply with all the written and verbal orders of your agent. Let your agent into your home at any time. Submit to a search of your person or property without need of a warrant. Report any changes to your agent within 24 hours. So even if you get stopped for a harmless reason, you didn't do anything wrong, but you have contact with the police, just make sure you report it to your agent. You won't get in trouble for that. You'll get in more trouble for not reporting it. So I just want to make sure that you understand, because you have the potential to do this very well and and have the YTA intact at the end of your probation, so I don't want anything to go wrong. And before you can use any additional prescription medications, you must advise any physician that prescribes those for you that you have a history of opiate addiction, and then you must provide a copy of the prescription to your agent as well as an acknowledgement from any physician. And Mr. Waits, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You are entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. There is an appellate rights form that we are right now emailing to Mr. Marks, and that explains more about your appellate rights. Just make sure that Mr. Marks, your client, has that in hand. And do you have any questions, Mr. Waits?
Not that I can think of off the top of my head. Thank you, Your Honor.
Okay. Then you are all set. Good luck.
Thank you so much, Your Honor.
Welcome. You should get contacted by the probation department themselves. They tell me they're reaching out, making the contact, but if you don't hear from them, please contact them.
Okay. I do have one question. What is exactly the MTR program?
MRT, it's also known as cognitive behavioral therapy, and which doesn't explain much, does it? Other than it's something that everyone can benefit from, and it's the only programming that I've ordered you to take. You might find it very useful because everyone can benefit from it, and it just talks about, it teaches us how the way we think changes how we act and how to make better decisions.
Okay.
I send a lot of people to it that really get a lot out of it, and it certainly can't hurt, so I think it'll be good for you.
Okay, perfect.
Okay, great. Good luck.
Thank you so much, Your Honor.
You're welcome. And Mr. Milks looks like he's got his client. Okay. We'll go back to that. This is People of the State of Michigan versus Obie Davis, docket number 20-229FH. And this is the time set for sentencing. Mr. Davis, can you hear me okay?
Yes, ma'am.
Great. Can you just confirm for me that you're okay with doing this sentencing remotely rather than coming into the courtroom?
Yes, ma'am.
Thank you. You were convicted of carrying a pistol in an automobile. That is a felony punishable by up to 5 years in prison. You have the right to be represented by an attorney. You are represented by Mr. Milks. And Mr. Milks, have you had a chance to go through the pre-sentence report with your client?
We have, Your Honor. There are a few corrections to be made to the body of that report, not to the guidelines.
Okay, I already corrected the attorney name on the face sheet, if that's one of yours.
It is.
Okay, go on.
All right. The attorney name, obviously the retained on just that first page, Your Honor. I think you've said you already corrected that.
Yes. And then the attorney name is wrong again under evaluation and plan.
Correct, Your Honor. Under the evaluation plan, then, Your Honor, on page 1, or I'm sorry, Your Honor, that's for allocution. Under family, marriage, family history, Your Honor.
Okay.
Where it says his son, Ojavion, his son is actually 9 years old, not 10.
Oh, down there. Okay. Are there twins?
No, they messed
Hold
it.
on, let me, no, Your Honor, his daughter actually, where it says O'Neill Davis, that's actually not anyone that he knows. His daughter is, Onaya,
Oh, Naya.
Onaya, and I can spell that for the court.
Go ahead.
O N as in Nancy, I-A-Y.
Okay, so the first son listed is 9 years old. The second one that they list, is not a child of his. And then I corrected the first name on his daughter.
No, and I'm sorry, O'Neill should be, I think, Onaya, who's actually his daughter, who is 10 in Mississippi. Kamaya is his daughter, who is 8 in Battle Creek. I know,
All right. The oldest child is Onaya,
correct.
and she's 10.
She is 10, yes.
The next one is Javian,
Yes, Your Honor?
9-year-old son.
Yes, Your Honor.
And then the 8-year-old is who?
That is correct in the report.
Okay.
Kamaya.
But he's 8, not 10.
I think what they did is with O'Neill Davis, I think they must have misspelled O'Neill Davis and then put son instead of daughter. That'd be my guess, Your Honor.
Okay.
I'm
I've made
not
all those
describing that well.
corrections. Any other corrections?
There are no other corrections, deletions, or additions to be made to the body of this report then, Your Honor.
Any objection to the scoring of the guidelines?
None from the defense, ma'am.
Okay, and do the people have any corrections to the report or objections to scoring?
No, Your Honor, thank you.
And do the people wish to be heard?
No, Your Honor, thank you.
All right, Mr. Milks.
Thank you, Your Honor. Your Honor, one thing that's, I think, kind of bugging me just about the report is it talks about how my client should engage in more pro-social activities, which I would agree, and I think my client would also agree would be a great thing. However, he is immunocompromised based upon his illness, which is listed in there. In fact, Your Honor, I'm sorry, one other thing is that on that first page of the report, it says where he's employed, and it says sickle cell anemia.
Right. Disabled, I'll put.
Thank you very much, Your Honor.
Go on.
Thank you, ma'am. My client is a nice guy. He's well-rounded. He's educated, fairly well-educated too. He puts himself in stupid situations, which is completely what is going on here, Your Honor. Speaking from personal experience, I know that when you're kind of sheltered away for a while, you kind of look forward to trying to meet people and going out and doing things, and sometimes you're not making the best choices. I would venture a guess that that's most likely what is going on here. He's a man worthy of rehabilitation, worthy of probation, and I think he can do very, very well, Your Honor. I think the only hiccups are going to be just trying to accommodate for probation, to accommodate with what his illness is and what some of the natural limits of those are. But there's no doubt in my mind that he is going to be an individual who can pass with flying colors the requirements of probation. Any sort of learning that he can do, I think, and even getting out and being able to talk to people to the best that he can, Your Honor. I believe he's going to do well, and I would ask that the court adopt the recommendations, and thank you very much.
All right, thank you. Mr. Davis, is there anything you wanted to say?
No, ma'am.
Okay, thank you. Well, I think that you're capable of doing well on probation also. This is unfortunately your first felony, But I think that there's plenty of reason to believe that you can fulfill all the conditions of your probation and go forward. But this situation, I don't know why you're riding around with 2 loaded guns on the front seat, but that just can't ever happen again. And, you know, I can easily look at it the first time, your first felony offense, and say, you know, okay, lesson learned, go on. But these conditions of probation are going to include things like you can't possess any firearm while you're on probation. And we are really serious about that. So I hope that you can heed that warning, and if you can, you'll be very successful on probation. I'm going to adopt the recommendation and place you on probation for a period of 18 months, 2 days in jail with credit for 2 days served. You have to pay $130 to the Crime Victims Fund, $68 in state costs, oversight fees in the amount of $180 payable at the rate of $10 a month. I am waiving costs. And additional conditions of probation are you may not use or possess alcoholic beverages or controlled substances or medical marijuana. You must comply with both drug and alcohol testing as your agent directs. You must complete a substance abuse assessment if your agent refers you to that. You must complete any outpatient or residential treatment you are referred to. You must complete the Michigan Rehabilitation Services Program. You must waive confidentiality and allow any treatment program that you're required to attend to disclose information to your agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. No contact with anyone you know to have a felony record. You must not change your residence unless you first get written permission from your agent. You can't possess any weapon while you're on probation. You must comply with all the written and verbal orders of your agent. Let the agent into your home at any time. Submit to a search of your person or property without need of a warrant. Report any changes to your agent within 24 hours. Be in your approved residence between the hours of 10 p.m. and 6 a.m. unless you otherwise get excused by your agent. And you must participate in an MRT or CBT programming if your agent refers you to that. Mr. Davis, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. We're sending that appellate rights form to your attorney right now via email. I'm asking him to hand it off to you and make sure that you have it. You should just know that the time period starts running from today. And you should be contacted by probation within about 24 hours, Mr. Davis. If you don't hear from them, then please contact probation yourself. Tell them that you just got placed on probation and you need to get going with that. Okay, do you have any questions?
No, ma'am. Thank you.
Great. Good luck.
Thank you, Your Honor.
Okay, and the next matter is the next matter Mr. Martin's, Ms. Allen? Okay,
Yes.
so I've got all 3 calling in, and I will admit everyone.
Thank you.
Okay. Looks like everyone's connected, okay? This is People of the State of Michigan versus James Caudill, docket number 20-352FH, and this is the time set for 1, an arraignment. I assume if it's set for arraignment, there's no written waiver, and then number 2, a bond motion. Is there no written waiver, Mr. Woolner?
That is correct, Your Honor.
Okay, so Mr. Caudill, you're being charged here in a 4-count information with 4 separate charges or counts of delivery of the controlled substance hydrocodone, and and in count 4, that's counts 1, 2, and 3, and in count 4, alprazolam. And each one of these is a felony, and each one of these is punishable by up to 7 years in prison. You have the right to be represented by an attorney. You are represented by Mr. Woolner, who's present, And Mr. Woolner, I assume I'm entering a not guilty plea for your client.
That's correct, Your Honor.
All right, then, we await formal reading of the information.
We do, Your Honor.
All right, then we'll go to your bond motion, and you may go ahead, Mr. Woolner.
Okay, Your Honor, in this particular case, my client has been in custody for 18 days now since a bond violation hearing. And it basically stems from the Achilles heel of my client. And we'll just be upfront and proceed with candor that my client is an addict. And that has been the cause of all his criminal cases and everything else going forward. Now, to take away the addiction problems, he's an honored veteran. He retired from the military at a young age with disability, but he was granted an honorable discharge. And he's had back problems ever since. And I think that stemmed into his addiction issues. But outside of that, he's never had any trouble with the law. He's Michigan born and raised, has the ability to do some slight work, but again, with his back issues, he can't do too much, but he does have a loving and supporting family. And I believe at this particular point, what is best for society and best for my client is focusing on those key addiction issues, which is why we're making the bond motion today. I would ask that the court release my client on a reasonable bond or perhaps even a PR bond so that he can go back to a rehabilitation facility to work on those addiction issues. And it is my concern that those issues are not being addressed in Ingham County Jail, especially with the COVID scare that recently happened. My client was in seclusion. I believe most of the inmates were while there was a flare up at the jail. And so when he's in there by himself in seclusion, he's not really working on those issues that he has. He's not dealing with those drug issues, addiction issues that can be worked on. And he does have a place to go if he were to be released. That the program had already said he is welcome back. And my client has informed me he's developed a good rapport with the pastor, one of the pastors that runs it, and a program manager. And so, you know, my client, he's not a violent man. That's not his MO. That's not his problem. I believe he poses a minimal, or at least a more or less minimal risk to society. And again, all ties back into those addiction issues. I do believe he is an honorable man. I do believe he can be rehabilitated and turned into a productive member of society. And I think that begins when when he gets into a good, solid rehabilitation and continues on with that. And I believe the court has within its powers the ability, which Jessica Amons talked about keeping him on a relatively short leash, monitoring him, but still allowing him to be out in society. And I would ask that the court release him so that he can enter into that program once again, Your Honor.
Well, let me ask you this. You mentioned bond violation. I have a report from pretrial services that's back from March. What is the bond violation?
Okay. Bluntly, he tested positive for heroin about in early June, and that's the reason why we that we're here today on this bond motion, because he was brought in, he admitted that he used, and it's been drying out ever since.
Did his bondsman surrender him, or was there a bond violation in district court? I mean, this is the arraignment in circuit court, so I've never touched this case.
Right. So this was a bond violation at district court, in which Judge Allen said, "Okay, you're going in for a little while," and you know, I believe I could be misstating Judge Allen. I don't want to, but I think he was leaving it up to you to kind of figure out how you want to proceed with the bond at this juncture, because it's more or less your case now. And we waived also at the bond violation. We also waived up to circuit court at that point. So if that makes it a bit clear as to why we did what we did.
And what treatment was he in?
Mr. Caudill, you mentioned the name, and forgive me, but it escapes me right now. Could you mention the name of the program you were in Lansing, the Lansing one?
In Lansing, it was Endeavor House.
Yep.
Okay, thank you. Mr. Martin, the people's position?
Your Honor, the people do not have an objection to releasing Mr. Caudill into a secure treatment facility where he can
get some inpatient treatment. The concern comes if he is in the community at large, or if he is doing some sort of outpatient treatment. I've had extensive contacts with his sister. Her name is Cindy Homant, and she is an employee of the state police. You'll note this was a state police investigation. She is not a sworn officer. She was not involved in the investigation at all. But she tells a very different story of Mr. Caudill, but it does revolve around this issue of addiction, seeking drugs, and seeking money to get drugs. I'll inform the court that since the bond report that you're reviewing, Mr. Caudill has had at least 2 other contacts with law enforcement that either have or will result in charges. He was charged with larceny in a building from an incident that occurred on March 10th. We have approved that in our office, but it has not been sworn to yet. So that's still pending. He was arrested for operating with the presence of a controlled substance. Oh, excuse me. The larceny in the building has been sworn to and is pending. He was arrested on March 26th for operating with the presence of a controlled substance. The case was furthered for blood work, and his blood came back with methadone in it. And that case has been approved by our office, but has not been sworn to as yet. So this leads to the areas of concern that Ms. Homant expressed to me and that I share. The first is obviously that Mr. Caudill is a danger to himself because of severe and worsening drug addiction. There's a familiar pattern that Ms. Homant describes in which Mr. Caudill will receive some funds every month at the same time of the month from the VA and from Social Security. And when that money comes in, Mr. Caudill goes on a binge, and there are these terrible things result, such as that OWI arrest on March 26th. He was in rehab in Ohio for most of May, which is something that I worked with Mr. Wallner to accomplish. And by all accounts, he did an excellent job when he was in rehab in Ohio. And we received very nice reports from the people in that facility. He was released on May 29th. He gets the influx of cash in his account. And on June 3rd, he was hospitalized for a suspected drug overdose that occurred at his mother's apartment. And I'll get to his mother's apartment a bit later because there is some important information there. After that, he went to Endeavor House here in Lansing, which is a sober living facility. And he only made it a week there. He was terminated from the program because he failed to comply with the rules and he failed a drug test. Again, for opioids in his system. And then most recently arrested on June 11th. He has made suicidal statements that cause us to have concern about his safety and about his mental health. And he made suicidal statements before going to rehab in May to his daughter, and those were communicated to me via Ms. Homant. I mentioned the OWI arrest, which has an element of public concern for public safety for me. He also had some vehicle issues in April, which leads me to believe that he's getting behind the wheel when maybe he's not safe to be getting behind the wheel. So we have that OWI arrest on March 26th. And in late April, in 1 week, he totaled his own vehicle. He damaged his mother's truck in an accident and had an accident in a work vehicle, all in 1 week. The other issue that the family expressed to me that they are concerned about is the mother, Betty Isaac. That's Mr. Caudill's mother. It's also Ms. Homant's mother, who I spoke to. Miss Isaac is a 72-year-old woman who lives in Grand Haven Place, which is a graduated care facility in the city of Lansing. And she lives there for 2 reasons. One is because She has a degenerative muscle condition where she requires some extra help, but also for most of 2019, she lived with Mr. Caudill and with a person who's associated with this investigation and has been charged separately, named Carrie Moran. And it's my understanding that Carrie Moran and Mr. Caudill have a romantic relationship of some sort. Anyway, during the time that they were living with Miss Isaac, Mr. Caudill's mother, there was some financial exploitation going on, at least what appears to me to be financial exploitation. I mentioned that he was using her car when he wrecked it, but in 2019, between Mr. Caudill and Miss Moran, they withdrew all the money from her bank accounts, moved all of the bills into her name, and those bills went unpaid. Ms. Homant took over as the power of attorney thereafter and moved Miss Isaac into this Grand Haven place. Ms. Homant informed me that Mr. Caudill was using his mother's debit card, and she was able to track at least $1,700 in uncharacteristic cash withdrawals in 1 month in 2019. Now, the only reason I say this is that based on my discussions with the family, Miss Isaac is somebody who loves her son very much and wants to help her son, but there is concern that her son's taking advantage of her and that her well-being might be in danger if he is released out into the community.
I'm sorry.
One further piece about this, Mr. Caudill was spending a lot of time at the Grand Haven Place facility with his mother in the days leading up to going to rehab, and then when he got out of rehab, which creates concerns for the family because part of the covenant they signed when they moved her into there was that there would not be other people spending the night in the house. And they are afraid that if he is staying there or attempts to stay there, that that she may be evicted, which the family worked very hard to get her into that facility, and they don't know what they would do if she could not be in that facility. So the fact that an ambulance was called there where he was going through an adverse reaction to controlled substances at that facility concerns them that it may lead to further action if it happens in the future.
All right, thank you. Mr.
Your Honor.
Wallner?
Thank you for allowing me to respond. I've had contact briefly with Betty Isaac and for Cindy Homans as well. I will say that I found out a lot that Mr. Martin has mentioned a lot that's not exactly sworn testimony that I've not come across, even though I've talked to those same two people. I'll leave it at that and just say that the court doesn't have any sworn statements there. And I would ask that we take it with a grain of salt. I just haven't seen the evidence for that. The one thing that does strike me is that there is a concern, and they all seem to point back to the same basic underlying roots of my client's problems, which would be addiction, which is our concern. It apparently is the family's concern. Anything else on top of that, any allegations of wrongdoing with the mother's bank account, that's news to me. I haven't heard that. But I would address or ask the court if we could just focus on necessarily the addiction problem. That's the key right here to rehabilitating my client and getting him to go in the right direction. Anything else, I'm not going to have my client speak to. It's something I've never heard of until exactly just a few minutes ago. That being said, Your Honor, I leave it to the court's discretion.
And Judge Allen actually revoked his bond, did he?
You know, my notes for that, it said that he was holding him on bond. I don't necessarily know if he used the word revoked, but I think it was moved to $25,000 and just basically being held on that. If the prosecutor, Mr. Mark, could correct me if I'm wrong on that.
Well, that's why I'm a little confused, because my records show he has a $25,000 cash surety bond not posted, but I don't know if that's what he had before Judge Allen saw him or if that's what he has after Judge Allen saw him.
My understanding is that after Judge Allen saw him last time, he never actually said on the record, and it did lead to some confusion between myself, the defense. I believe the prosecution was kind of wondering, geez, where exactly are we with that? And correct me if I'm wrong, Mr. Prosecutor, but I believe that's where it was after the bond violation hearing.
Okay, that makes absolutely no sense, because then why is he in jail? I mean, other than Judge Allen could have found him in contempt for violating bond, but that would be a specific number of days sentence, so.
I don't believe my client had the ability to get out onwards. It was just too much money that he simply didn't have to bond himself out after that particular point.
Okay, all right, thank you. Well, there are a number of things that I just will not consider, and I've read the bond conditions court rule many, many times, and I'm really positive it does not say in there that you can keep someone in jail for protection of themselves. We have other laws that protect people from themselves if they're a danger to themselves. But it focuses more on the impact that they may have on the community. And the bond report that I have shows that Mr. Caudill does indeed have a significant substance abuse history, and it also shows that he has a previous controlled substance misdemeanor conviction, and then a very old operating while under the influence conviction misdemeanor. But it appears that he not only violated a condition of his bond per Judge Allen of not using any controlled substance, but actually has new charges that are coming. And it would appear to me that he is indeed a threat to the safety of the community. And I'm not sure if this $25,000 cash surety bond is actually still in place or not, because it's really unclear to me what happened in district court. But I would set a $25,000 cash surety bond on this case, and a condition, if he makes that, would be not to use any controlled substances and to engage in substance abuse treatment while on bond. And that I will not make a further reduction in the bond from that. And that concludes this hearing.
Thank you, Your Honor.
All right,
Thank you.
Thank you. Okay, that takes us to an in-person sentencing. People of the state of Michigan versus Dean Baldwin.
How do you want us to do this? Podium separated? I don't know. I could stand over here maybe? And
That's
you could stand
fine.
over there?
Yeah.
I just don't know how you want it done, Your
Yeah,
Honor.
Mr. Baldwin.
Come on up.
One thing they never trained me for was being the traffic cop in the courtroom, so if,
So
yeah,
stand on the other
wherever
side here from us,
you'd
so
like,
distance a
just
little bit.
keep a distance from your lawyer, please. We're not afraid of you, we just, we're trying to follow the rules. This is People of the State of Michigan versus Dean Baldwin, docket numbers 20-133FH and 20-135FH. And this is the time set for sentencing, Mr. Baldwin. On this first file, you were convicted of first-degree retail fraud, a felony punishable by up to 5 years in prison. And then on the second file, you were convicted of first-degree retail fraud, a felony, and because the prosecutor was proceeding against you as a habitual second offender on that case, makes the maximum penalty up to 7.5 years in prison. and you have the right to be represented by an attorney. You are represented by Mr. Cornish. And Mr. Cornish, have you had a chance to go through the pre-sentence report with your client?
We have, Your Honor.
And do you have any additions, deletions, or corrections?
None to the body or the guidelines, Your Honor.
Okay, and Ms. Allen is joining us via Zoom, and Ms. Allen, did the people have any corrections to the report or objections to the scoring?
Only the one you already caught, Your Honor, in that I think the PSI doesn't reflect the habitual second on that second file, but that's our only correction to the body and the report.
Yes, that is correct. I forgot to mention that on the face sheet, docket number 20-135 should reflect the habitual. So, I go to, I'll just put and as a second habitual offender in docket number 20-135 only. And that was your only one?
Yes, Your Honor.
And no objection to the scoring of the guidelines?
Well, I guess on that same note, Your Honor, because there's the habitual second, then they would change on the scoring sheet.
That's right.
It would be 10 to 28 instead of 10 to 23. And then the statutory max is 78 months.
So we have to put, well, this is habitual, yes. I'm looking at the guidelines now, so habitual, yes. And then 10 to 28, and what was the last one you said?
The statutory max, Your Honor, would be 78 months.
Oh, yeah, okay. 78. Okay, I changed all of those. Okay, so that should cover it for the guidelines, and did the people wish to be heard, or was there a victim who wished to be heard?
No, Your Honor, thank you.
All right, then Mr. Cornish.
Thank you, Your Honor. Your Honor is aware of the plea arrangements that were made in this case. I guess I would ask the court to follow the Killebrew and maintain that primarily. That having been said, I did kind of touch base with Ms. Allen about this a little bit earlier. I realize the court hasn't found good cause based upon the outbreak currently in the county jail alone to not issue people a non-jail sentence. But I think that the court could find good cause here, with there being last reported at least 10 cases, if not more, currently in our jail. This is not a violent crime. Clearly, my client has a problem with other people's property. I think that the threat here is more to a financial threat if he were to continue committing crimes, not necessarily a wanton, harmful, physical threat, is I guess what I'm trying to go for. But I think there's a little bit of a difference. If this had been some sort of great bodily harm or assault of nature crime, I certainly wouldn't understand. That having been said, we do take it serious. He does have a lengthy history, and I understand the court's position and thought. His guidelines are 10 to 23. I'd ask the court to consider probation in this matter, primarily because I don't know that it's a good idea to send somebody into a petri dish at this point in time. He's been doing very well since he's been with these cases pending. I think the court supervision could help him continue doing very well and minding his P's and Q's. There was some issue about another case that had been taken care of. I believe Ms. Allen has now processed that. It was supposed to be part of our original plea agreement. So that's gone. And actually, I guess that had to be corrected if it still says that on the cover sheet. So that's our position at this point. We'd ask the court to consider doing it, I guess it would be below the guidelines, into a probationary, or even sentence him to 10 months with credit for time served that he's already done, and suspend the balance of that sentence pending probation. So it could still kind of be within the guidelines at that point. Thank you, Your Honor.
Okay, thank you. Mr. Baldwin, anything you would like to say?
I'd like to mainly reiterate the aspect of you considering probation for. I do believe that would be a good decision. Right now, personally, I went through some things dealing with the life that I live, and this is a true story. My daughter she left home, and she was living with her mother, and a couple of individuals that I used to deal with, doing things that I was doing, took my daughter in, and she's 18, so she wanted to be on her own, and they catered to that. Make a long story short, they ended up trying to sell my daughter, and some individuals that I know found my daughter for me. And now my daughter's living with me now. And like I told Mr. Cornish, on the way here, it's like, as much as I don't want to, go to jail, if I have to, I know it's going to be a little bit of time. What I just went through in my life, there's a world where there's safety. That I'm going to be gone for a little time. But, like I told my daughter, I just got to take care of what consequences of what you do in life. And I never was the one to, plead or, I always, pled guilty, like when I'm drunk. I told the police I was drinking. I'm not a liar. I've never been a liar. I don't like liars. And so, with that, I just ask for mercy of the court. Whatever decision you make, Judge Draganchuk, I'm going to take care of it. Get this behind me.
That's a terrifying story about your daughter. I can't imagine, even with your extensive prior history, that there was anything more painful than what you went through with her. Maybe that's a time that makes you think about how you live your life and how you might want to change some things.
Yes, ma'am. That was all I needed.
So the very people you were running with did this to her?
Yeah, because we fell out. We fell out. Yeah, over some money. Yeah. They don't like me. It's a lot of people that don't like me. Yeah.
Well, it's definitely time to reassess your priorities.
Oh, yes, ma'am.
Yeah.
Yes, ma'am.
And, think of the safety of your daughter, because, I don't think I even have to say it. These are the people you were running with, and they do this to her. That should be done deal right there. I hadn't anticipated this sentence, but your attorney makes a valid point. I don't want to endanger your health. And there apparently no one's directly informed me, but I watch the news. It would be nice if they told me. But I learned on the news that there was an outbreak at the jail. So, and this is a nonviolent offense. Let's just be honest here, as bad as your prior record is, this is a nonviolent offense. You do it over and over and over and over and over.
Yes, ma'am.
But let's just see how it goes, okay?
Yes, ma'am.
So I am going to place you on probation for a period of 24 months,
Okay.
86 days in jail with credit for 86 days served. That's on each file. On each file, you owe a $130 crime victims fund, and on each file, $68 in state costs. On docket 133, you owe restitution to Target in the amount of $182.92. And additional conditions of probation are no use or possession of alcoholic beverages, controlled substances, medical marijuana, or possession of any paraphernalia, drug paraphernalia. Comply with both drug and alcohol testing as your agent directs. You must complete a substance abuse assessment if directed by your agent, and engage in whatever outpatient or residential substance abuse treatment your agent refers you to. You must, just doing this on the fly, so make sure I get everything here. You must waive confidentiality and allow any treatment program that you're in to disclose information about you to your agent. Alcohol's the issue, yes? Did I hear you say that,
Yeah,
sort of?
Well, it is, but it isn't. You know, like I said, I stopped using cocaine years ago. I don't smoke weed.
Okay. Well,
But I have been depressed lately.
Okay.
So, and I have, you know, so I mean, yes, it is. Yes,
Okay.
It is. I mean, there's
Yeah,
no
let's
way,
be real.
there's no way to really beat around it. You know what I'm saying? It's not like,
Nope.
because as I think about it, as we're talking about it, you know what I'm saying? It is because I was drinking because I was depressed, you know, I was going through a lot.
All right, so this is no time to beat around it. This
Right,
is the
exactly.
time for brutal honesty with
Right,
yourself.
exactly.
We'll do 90 days on Scram Tether
Okay.
in order to monitor that. And you must not change your residence unless you first get written permission from your agent. You may not have any contact with anyone you know to have a felony conviction. You may not be on the property of Target or was it Meyer?
Yes, Myers.
Meyer or Target. You must comply with all the written and verbal orders of your agent. Let the agent into your home at any time for a search and submit to a search of your person or property without need of a warrant. You can't possess a weapon while you're on probation, and you must report any changes to your agent within 24 hours. And you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that. If you're making a request for one, you have to make it within 42 days of today's date. It explains that more on the forms that you are now holding, one for each file. That's why there's two of them, but they're identical. And I don't think they're still seeing people over down in the probation department.
I think it's all by phone, Your Honor.
It's all by phone, that's what I thought. No one's told me otherwise, so, but no one told me.
Your Honor, can I ask, I may have missed it, but did you give the restitution on there too?
To
Okay.
Target, yes, on the one file.
Thank
Yeah.
you.
So probation is supposed to contact you within 24 hours. If they don't, please make sure you contact probation
Okay.
by phone.
Yes, ma'am.
And because you need to get hooked up right away on Scram Tether,
Yes, ma'am.
okay?
Okay.
Good luck.
Thank you so much, Judge.
Thank you, Your Honor. I gave him another copy of my card. If he has problems with probation, I can assist him.
Yeah, sometimes people have had trouble getting through, so.
Have a nice day.
Thanks, Judge.
All right, that takes us to sentencing with Mr. Petrovich. I see that he is calling in. And he's with his client. Okay, this is People of the State of Michigan versus Mikhail Brown, docket number 20-179FH. And this is the time set for sentencing. Mr. Brown, can you hear me okay?
Yes, ma'am.
All right. And could you just say for me that it's okay with you that we do this remotely rather than bringing you into the courtroom?
Yes, I'm fine with that.
Thank you. Mr. Brown, you were convicted of carrying a concealed weapon. That is a felony punishable by up to 5 years in prison. You have the right to be represented by an attorney, and you are there sitting next to Mr. Petrovich. Mr. Petrovich, have you had a chance to go through the pre-sentence report with your client?
I have, Your Honor.
Do you have any additions, deletions, or corrections?
No, Your Honor.
How about objections to the scoring of the guidelines?
No objections, Your Honor.
Did the people have any corrections to the report or objections to scoring?
No, Your Honor.
Okay, did the people wish to be heard?
No, Your Honor, thank you.
All right, Mr. Petrovich.
Yes, Your Honor. I believe that the recommendations in the report are appropriate for Mr. Brown. I know in talking to him about the different things, including the right turn program and his hopes for his future, he's actually eager to get involved with a lot of that program. He's also fully aware of the benefit that YTA status would give him in his future as well. So I would ask that you follow the recommendations in their entirety. I also want to touch on the fact that it does reference in here that the report writer was somewhat worried about the potential for his own family associations having some issues with that. But I'd like to say from my experience, his mother and foster mother are here today. They have been here at every single court day. I've talked over things as much with them as I have with Mr. Brown, and they are eager to keep him away from the associations that led him to this behavior in the first place. And I think that they're going to be wonderful influences going forward. So that's all I have to say. Thank you.
Great, thank you. Mr. Brown, anything you wanted to say?
No, thank you, Your Honor.
Okay, well, you are young and you have absolutely no criminal record. And so I'm thinking that even though you are unemployed, according to this, you have a GED and you have the potential to go out and do something with yourself. And I think that you have the ability to do that. I'm not gonna lie though, this situation that I read about in the pre-sentence report, running around under what sounded to me like some very bad circumstances with a gun. And that is very dangerous behavior to you. I mean, I'm concerned about the community, but I'm concerned about the danger it represents to you. So, you know, we want you to have a healthy and long and happy life. So, you know, you need to think about that behavior and the seriousness of it and how it landed you here in circuit court on a felony charge. So, you know, I always tell people that have potential and have good things going for them that you make a bad decision like that and you can wash away all the good things and end up, you know, basically jeopardizing yourself and end up in jail or worse. And there go all the good things and all your bright future. So I think you are completely appropriate for the Homes Youthful Trainee Act. I have no problem granting that, and I expect you to do very well on probation. I'll place you on probation for a period of 18 months, 2 days in jail with credit for 2 days served. You have to pay $130 to the Crime Victims Fund, $68 in state costs, oversight fees in the amount of $180 payable at the rate of excuse me, $10 a month. Costs in the amount of $250 based on the State Court Administrative Office calculated average cost of a criminal case in Ingham County, which is actually a drastic reduction from that. And additional conditions of probation are no use or possession of alcoholic beverages or any controlled substances or medical marijuana or drug paraphernalia. Comply with both drug and alcohol testing as your agent directs. You must complete a substance abuse assessment if you are referred by your agent, and complete outpatient treatment if your agent refers you to that. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. No contact with anyone you know to have a felony record. You may not change your residence unless you first get written permission from your agent. You can't possess a weapon while you're on probation. And you must comply with all the written and verbal orders of your agent. Let the agent into your home at any time. Submit to a search of your person or property without need of a warrant. Report any changes to your agent within 24 hours. Be in your approved residence between the hours of 10 p.m. and 6 a.m. unless you're excused by your agent. And make genuine efforts to find and maintain employment a minimum of 30 hours per week. And then this last one I really like for you. This is a very good program, and that's the Right Turn program at Peckham. I think that could do some great things for you and head you in the right direction. So I'll be looking forward to seeing you take part in that. Mr. Brown, you have the right to file an application for leave to appeal your conviction and your sentence in this matter. You're entitled to an attorney at public expense to assist you in doing that, and if you're making a request for one, you have to make it within 42 days of today's date. It explains that more in a form that we are emailing right now to Mr. Petrovich, and I'll ask him to hand it off to you. And that is all, unless you have any questions. Mr. Brown, do you have any?
No, I just want to say thank you, and I completely understand. I just want to make sure I get it through, and thank you for letting me be on the right turn.
Oh, you seem like a very nice man, and I wish you good luck.
Thank you.
Okay, then that will conclude our sentencing.
All right, have a nice day, Your Honor.
Thank you, Your
You
Honor.
too. Okay. And the last one was to be in person at 3:30, which it is right now. But I do not have Mr. Feinberg in the courtroom. I'm going to end our YouTube live streaming until we're ready to